period. Next week, any date.
Other side.
Government look. Can we please to fix next week any date? Dismissal from service.
The key political concept of the petitioner has paid for a short adjournment. Please after 2 weeks.
Document take the date next week any date.
I'm paying for listing the matter for motion on Friday.
Filed or not?
Yes, we start.
This bench matter.
Yes, ma'am. Yes. Was it pay for similar pair listing of the pending case, Lord?
Pending case. Which year?
One WPC of 2021 pension matter, and another is contempt matter. It was listed for 2 occasions. Notice has not been issued here because the matter became late covered.
On Friday.
May please, your lordship. First, I beg to mention item number 3, lordship. Matter became infectious, my lord.
3. What is your name?
Is Rahman, lord.
3. Mr. Education Department, anybody is there? Education. We want to record the name of some counsel, whoever is present in the court premise. Mr. Goswami, anyone from the Education Department whom we have seen in the court today? He is there. He is there. 3. H. Brahman, counsel for the petitioner, submit that by effect of time. The matter has come in factor. Also heard 3 SNPTC, standing counsel, Education Department, petitioner is dismissed as factor.
Obliged.
May please, Lord. Okay, in this case, client has instructed us not to place this matter, and accordingly, they paid. They has written letter with their lawsuit.
3. K. Colita, counsel for the petitioner has submitted that K. Colita, counsel appearing on instruction of 3. E. Sharma, counsel for the petitioner has submitted that written instructions have been given by the petitioner not to press this petition. Also heard 3. K. Goswami, counsel for as a government counsel.
Lordship. Additional thing government. 1 and 2, lordship.
Additional
For 1 and 2.
some
I am for 4, 6, 7.
who are
Private
Private.
for paying for private responder 4, 6, and 7. Sharma, what is your name? R. Chauhan. R. Chauhan, counsel for the responder number 9. 5.
And for 4, 6, 7, 8, 10, and 11.
4, 6, 7, 8, 10, and 11. And you for responder number 5. Petition accordingly 10 dismissed on a trial. Copy of written instructions is kept with the record. You we will make a photocopy. We'll have
I have photograph.
no, you have the original. This is not this
Okay. I
you pick off the no. Dekha, you're not there to go. It was ready to do. Original to take it right here.
I'll leave it.
Look for the petition.
Supervisor also the matter pertains to the areas, salary and other benefits of the petitioner who work in the state tribunal. And upon liquidation and further, he has not opted for VRS and rather he has filed the application under a labor
Okay,
code.
will none appears for the petitioner for whereas the chief order lieutenant standing on the co-person department is present. This is a matter of the year 2012 and has been listed under the column top of the list. Sarah, be that as it may, and in the interest of justice, a further opportunity is granted for the petitioner to represent himself. Please again on Thursday. Next following. Day after under the column top of the list, it is however made clear that if there is no representation on the next day, this court would pass appropriate orders. In fact,
Your Lordship, my lord, as per order dated, earlier order,
2012 recruitment, word boy,
my lord, 10/7/2017.
yes,
Can you speak? I am the ward girl, my lord. I passed the written examination, my lord.
This is what
Uh,
boy, these cases of what boy, appointment of what boy.
What boy, my lord? What boy, my lord? And my lord, the Haiba, I am, my lord, not successful.
Mm.
So record maybe record as per order date is record is required, my lord. This I am not the selected candidate. I have no right.
2012 matter will not wait for the record. Have you filed an affidavit?
Yes, Lordship, in
Based
the,
on the building will dispose this of. We can hear you.
in our affidavit,
my-
Lordship, para 8, we have already stated all this case, Lordship. The record is not available, Lordship.
What is your
My lord, the further opportunity may be given.
2012? Yes, what is your matter?
As per advertisement, my lord.
That was
I
saying.
have
4754. Yes, what is the matter? There was a
as per-
advertisement.
what boy, my lord?
Advertisement dated
21/10/2021. 15 post
21.
10/2011 as per advertisement.
Appointment
I-
of what boy?
What boy?
How many posts?
15 post.
Where?
15 post, my lord.
Where in the Guwahati Medical College?
Yes, Lord.
2 post for STP, 3 post for OBC, MOBC, 2 post for SC, 1 post for LTH,
Total 15 posts.
and well, 7 unreserved post.
Total 15 posts.
15 post
You are unreserved.
unreserved.
15 total
7 post unreserved.
for you are. Yes. Then what happened?
Well, I applied, my lord, page, my lord, 16, annexure 4, my lord.
Next
This
step
is the, my lord, this I appear in the written test examination on, my lord, as per date, order date, my lord, 23/5/2012, my lord. Page 16.
10/6/12 was the written test. 10/6/2012. Correct?
23/5/2012, my lord.
No, no. 10 10/3/10/6/2012.
My lord, I appeared, my lord.
Then
6, 2012.
yes, there you appeared.
Appeared, my lord.
Hmm.
And I was successful, my lord. Thereafter, in the, my lord,
Where is the select list?
my roll number, my lord, 202735.
Where?
My lord, this page 17, my lord. Page 17.
Yes.
In my lord, the right side, my lord, before 3 lines, my lord,
What is your roll number?
202735.
2027.
35. I am on a written test successful, my lord. 202735.
Right. Okay. Successful.
Thereafter, I appear in the, my lord, oral examination. I am not successful in the oral examination. Lord, my grievance, my lord, I am well done in the oral examination. My lord, some tested interest candidate is the selection list as per, my lord, instruction from my client, my lord. That is
What-
my grievance, my lord.
What's the basis that you had done well, or somebody who was less meritorious than you have got the appointment?
I stated, my lord, my
Right.
paragraph 5, my lord.
Paragraph 5 page.
In it, petition.
Page 6.
Page 6, my lord.
Yes.
Five and 6, my lord.
Now, what is the basis of saying
Fine.
that?
This
It
is
is
my
illegal.
grievance, my lord.
What is that? It is illegal, arbitrary on what basis?
My lord, this I am done well in the, my lord, oral, and my lord, this
No,
other procedure-
others might have also done well, or might have done better than you.
that is why, my lord, this
To stake a
In the
claim.
oral examination, he was not qualified. Neither is
Understood.
Ah.
No, to stake a claim that you have done well, you have to say that you have done better than the others, and the others were not. Their performance was not as good as you. Where have you stated?
my lord, that is why, my lord, as per, my lord, this honorable court's order, my lord, 10/7/2017,
Your
that is my grievance, my lord. Otherwise, no right, my lord.
petition is lacking in pleading. You should have come up with some grounds that these candidates are there, they are not even qualified, or they have been favored. Pleadings are vague and
On the basis of the mark, my lord, the oral exam,
inadequate also.
that is my grievance, my lord. Your lordship passed
You
the-
have filed affidavit.
Yes, Lordship.
What have you stated?
Lordship may kindly come to para 8, Lordship.
in their affidavit, my lord,
Affidavit-
paragraph, my lord, 7
Affidavit,
also.
when did you file? What is the date of filing? The affidavit,
27
27 November 17.
27 November. Okay, but
The
what is
flag mark is there. Lordship.
yes, what have you stated?
In para 7, Lordship, we have stated that petitioner
it-
passed out successfully in the written test for the post of ward boy. However, in the viva voce test, petitioner could not come out successful. It may be stated that the selection for the post was made on total marks obtained by the candidate in the written and viva voce test. Then, Lordship, in for para 8, Lordship, the deponent lecturer said that it is not true that the following candidates did not appear in the viva voce test. The following candidates duly appeared in the viva voce test, that is 1 to 7. Jayanto Deka, Manjur Ali, Mukesh Kalita, Navakumar
Okay.
Deka, Nazrul Ahmed. The detailed select list as sought for by the petitioner could not be provided
Okay,
since
that aspect will not go in. Okay.
Yes.
But there's an counsel for the petition. also heard MS D. Bora, Learned Training Council, Family Health and Family Welfare Department. The issue involved is with regard to a recruitment process initiated by an advertisement dated 21/10/2011 for the post of ward boy in the Guwahati Medical College. Also, the state process was initiated for total 15 numbers of posts, out of which, 7 posts were for unreserved category, to which the petitioner belongs. It is the case of the petitioner that, being qualified, he had submitted his candidature in response to the state advertisement, and on 23/5/2012, call letter was issued to him for the written test, which was scheduled on 10/6/2012. Also, the petitioner had appeared in the state written test with roll number 202735, and also the Hussein, the Learned Council, has referred to results of the written test, which was published in the Dainik Janahadharan in its issue dated 18/12/2012, wherein he was stated to be qualified in the written examination. Also, it is the case of the petitioner that he had also fared well in the oral segment, and in spite of which, he was not amongst the selected candidates. The Hussein, the Learned Council, has drawn the attention of this court to the averment made in paragraph 5 and 6 of the writ petition.
Malo 10 also.
10/10.
Malo
Same. In paragraph 5, it has been stated that there has been illegal,
7.
arbitrary, and malafide action of the authority in not selecting the petitioner. In paragraph 6, the petitioner has cited 7 rule numbers, and has made an allegation that those candidates did not even appear in the oral interview and were, however, selected. The Learned Council, according to submit, that the selection be set aside and a direction be issued for consideration and appointment of the petition. MS Bora, the Learned Training Council, however, submit that there is no foundation of the challenge made in the petition, and the petition suffers from the petition is, and in the petition vague allegations have been made. He submits that though established that the recruitment process consisted of two components, written and oral, and only on being finally qualified and selected, appointments were offered. In the instant case, while the petitioner could clear the written examination, he did not, he could not qualify in the oral examination and therefore was not amongst the selected candidates. By drawing the attention of this court to the affidavit in opposition filed on 27/11/2017, the learned counsel, the learned standing counsel has referred to the amendment made to paragraph 7 of the state affidavit, which is a reply to paragraph 5, wherein the allegations have been categorically denied. Reference is also made to the amendment made to paragraph 8 of the state affidavit in opposition, whereby the allegation that 7 numbers of persons did not appear in the oral examination has not only been denied, but the details of the candidates have also been stated. The rival contention made by the learned counsel for part have been duly considered, and the materials placed before the court have been carefully examined. The challenge, as mentioned above, is with regard to a recruitment process in which admittedly there are two components, namely written and oral. Mere qualification in the written examination would not be enough, and it is the consolidated result of both the written and oral which would make a candidate eligible for appointment based on the merit and the vacancy position. In the instant case, though the petitioner had appeared, was successful in the written examination, he could not qualify in the oral examination. The allegations of illegality, arbitrariness, and illegality and arbitrariness made in paragraph 5 of the writ petition are not substantiated by any materials on record, and apart from in any case, such allegations have been categorically denied in the affidavit in opposition. Though the petitioner had tried to make out a case by citing 7 rule numbers with the allegation that those persons did not appear in the oral interview, such allegation has also been categorically denied in the affidavit in opposition. It is a settled position of law that unsuccessful candidate who has submitted to the jurisdiction of a recruitment process cannot be allowed to turn around and challenge the selection only because of the fact that such candidate had come out unsuccessful. Also, in this case, one may gainfully refer to the cases of Madan Lal versus Twins and Twins, wherein it has been stated as follows. the aforesaid law may have some exception, comma, in the instant case, no case at all has been made out for a writ court to embark upon a dispute which is factual in nature and is also factual in nature. Also. In any case, comma, the allegations have been categorically denied in the affidavit in opposition, and therefore it may not be possible for a writ court to enter into such disputed questions of fact in view of the aforesaid fact. This court is of the opinion that no case for interpretation is made up, and accordingly, the writ petition is dismissed.
My lord, already, my lord, paragraph 8 already published in the, my lord, that time, my lord, the paper publication also, my lord, some illegality there. I annex that, my lord.
Paper can write anything. Mr. Chaudhary, which matter?
I think that. Hearing.
Malad, matter may kindly be passed over for the time being. I am led by Senior Counsel Mr. UK Nair.
What is this matter?
Lordship, in this matter, we have a communication seeking some more time, Lordship, because some documents are necessary.
What is
and
the
which
matter?
My lord, regarding petitioner, my lord, before your lordship is working as a professor in Amiya Kumar Das Institute of Social Change. My lord, institute has all throughout, my lord, followed the UGC rules and regulations so far relating to pay scale and conditions of service. In fact, my lord, the government of Assam, by way of a cabinet decision, has increased the age of superannuation of all professors within the state to the age of 65 years.
Right.
My lord,
Right.
thereafter, my lord, but the institute is not, that benefit, my lord, age of superannuation is not given to the.
What is the
Lordship, the TND department is seeking time, Lordship, because they have called for some documents which to be furnished by the Higher
when-
Education Department, Lordship.
when can you get the document?
Lordship, at least 3 weeks time,
My
Lordship.
lord, that will be difficult, my lord.
3 weeks, 22 matter.
Well, let the matter come up after some time. Senior counsel will be here, my lord. A date
Because
may be fixed.
we have the communication, even if your
I
Lordship.
will grant you some time. but
Yes.
We'll fix the date. What is your age, Mr. Chaudhary?
My lord.
What
I'll
is
be
your age?
retiring in February next month, my lord.
Next month. Next
Next, sorry, my lord, next year.
Next year,
First part of February.
Okay,
Then
we'll
Lordship.
fix a date.
Lordship.
I'm Bhattacharya. An additional senior one, submit that no affidavit in opposition has been filed, comma.
The pleading is complete. my
It
lord.
is complete, Lordship.
Then
Further
what-
instruction,
Order
Lordship.
instruction, my
The
lord.
affidavit in opposition has been filed, comma. There is requirement of a further instruction
TND department.
is on the offing. He accordingly placed for some time. Para. On the other hand, comma, Sri Chakraborty, that is counsel for the petitioner, has apprised this court that the petitioner would be retiring in February 2024. So, para, considering this, that is, let a short adjournment be granted and the matter be listed on. Madam,
Within this month, my lord, on a hearing date, my lord.
today is what?
Today it's 12, Lordship,
Let
We'll
it
have
be
it
on
on
19th,
26,
my lord.
26,
26,
yes,
Lordship.
Tuesday. But don't fail on 26, 2 weeks.
That may be reflected, my lord, without.
Lordship.
We'll remember, yes, next.
Oblige.
Declare.
May it please your lordship.
Yes, yes.
Lordship, I've been led by senior advocate Mr. UK Nair. He's on legs in court number 6. May it be taken up some time, man.
May not be possible.
At 2 o'clock,
My lord, even the opposite counsel.
there's a medical admission matter going on, Lordship, in court number.
Then Thursday. Is there any urgency, Mr. Sharma?
Urgency is that, my lord, the new selection process is going to begin for the post. To be,
Which post?
for the Department of Microbiology, my lord. Senior resident doctor.
Assistant professor,
Assistant is associate.
assistant professor in the Department of Microbiology in AIMS. ma'am.
Thursday,
Thursday, my lord.
Much obliged.
prayer for adjournment has been made on behalf of the UK and Ireland Senior Council. List for hearing, list for admission, list for admission on Thursday.
Much obliged.
Sharma?
Lordship. All the parties consented to file their affidavits by today, my lord.
Filed or not?
No,
No, lordship.
Lordship, I have 6 months time, Lordship. To file that.
You filed or not? Not
No,
filed.
Not filed.
Have you got the instructions?
Lordship, Lordship,
That matter, geology.
need some
Yes,
time,
lordship.
need some time to file my.
It's been dragged on and on and on, my lord. I have now no more submissions to make except what is there.
On 23 we had taken a matter. Now somebody else has been given the charge who is not in the cadre also.
Yes, lordship. And that too, he is holding multiple posts. This is a purely technical post. Since-
Why this thing?
On that regard, I have to take the instruction.
No, why,
Next
what
week.
is the reason you ignore somebody who is from the department? You bring somebody from the All India service who is not even connected with this department. This is a specialized department.
Lordship.
And it's not that he is out of job. He has got, he's been entrusted with a number of other jobs. You make him additional director or in charge director.
Next week, Lordship, I will address all this.
No, in one of the cases where interfered, I think forensic science. Mr. Sharma, you take out that case.
Lordship.
Forensic science, a similar matter had happened. The director was thought to be replaced by somebody, an IS officer.
Lordship. Yes.
We said that you go ahead with the permanent recruitment, no problem. But if you are having an in-charge basis, why do you bring an IS officer who's already burdened?
And lordship, this is what is happening since 2017 and this petitioner has.
And if you hold a regular process for recruitment, I think he is eligible. He is in the cadre, not only in the cadre, he has got the eligibility criteria to at least participate in the selection.
Yes,
And
lordship.
the person whom we are bringing in, he's not even in the cadre. He's not even interested. Why are you? What the easy way you have, you are making it complicated. Next Tuesday.
Lordship.
But next Tuesday, come up with instruction.
Lordship.
First creation for the petitioner. Also, J.K. Goswami.
For 1 and 2, Lord.
For response 1 and 2 and Lenso for and Lenso for response number 3. So you have filed affidavit now.
No.
Do no. The Sri Sharma, the learned counsel for the petitioner, has pointed out that when this matter was taken up for consideration on 23/6/2020, this court, while issuing notice, had also observed that the case would require an expeditious disposal, and
Lordship.
therefore had directed the learned counsel for the case to obtain necessary instructions. However, such instructions are not forthcoming, is not forthcoming till date. Instructions are where Sri Goswami, the learned state council, have raised for some more accommodation. That a final opportunity be granted and the matter be discussed on Tuesday next week. For
Obliged.
Wait, please, your lordship.
Yes.
My lord, in this matter, your lordship said you should notice on 23rd of June,
Hmm.
making it
Will
returnable by
file.
2 weeks. No,
lordship, instructions are.
File the affidavit. What is the matter?
Lordship, no extra copies has been furnished till date.
no,
Lordship.
it has been done. It has been done.
You give another extra copy,
Lordship,
Mr. Doctor.
thing is there.
Well, my instructing counsel
No,
said
give
that
another copy. There's no problem. Government is very poor nowadays. Uh, Our Priya Dutta Senior Council for the petition. Also heard. Mr. Gogoi for
Respond number 1, 2, 3, 4, 5. 1, 2, 3, 4, 5.
Forest Department.
Forest Department, Lordship.
Also, they are
For
Gogoi.
7 and 8.
Senior Council Forest Department. Whereas MSM Bhattacharya, additional senior governor Phuket is also present. The MS Bhattacharya has paid for an extra copy of the writ petition, which Mr. Datta has undertaken to be furnished during the course of the day. Let the respondent, the Learned Council for the respondents have also paid for time to file affidavit. To obtain instructions, let's file affidavit. This, after 3 weeks,
my lord, can a date be fixed?
tell us.
The October 12th of October.
As agreed to by the parties. So,
12 of October. Okay.
yes,
Lordship.
Obliged, Lordship.
Obliged.
Lordship, in this matter, we were asked to bring the instructions, Lordship. I've got the instructions. Actually, we have missed the case today, Lordship. Our name was not known. I just been informed. I've got
SAG,
GAD, man.
GAD.
I've got the instructions, but
Friday,
Friday, man.
part 3 Alukogo Learned Council for the petition. 3 A Fukan, Learning Council, CAD,
GAD.
however, informed this court that two instructions have been received from us. The same is not readily available as because this has not reflected the names of SPGAD. List on Friday next by reflect the name of SPGAD in the call.
DPM.
Friday, this Friday.
15.
15.
DPM.
On the matter, Mr. Khan, yes.
Hello. So the respondent name has already been appeared. Nobody is there, there is a direction of this honorable court that is based. Start from 11.
Yes, who's appearing for
Here, director has submitted the proposal, madam. It is under process to provincialize the service of the petitioner school, madam.
how when can you get it?
How much? Madam, after 3 weeks. It is. before
Part
the
3
government.
M. Khan, Learned Council for the petition. To be border, Learned Council appearing for the respondent. However, submit their steps have been taken for compliance of the order in question, and within some more time, you would be in a position to apprise this court regarding the full compliance. This up to 3 weeks.
Obliged.
And a clear pay for a particular date loss.
Contact method.
May please, your lordship. Your lordship, in this matter,
We take a for final disposal.
Yes, sir. Your Lordship, in this matter, the 4 petitioners are working as contingent workmen in ONGC, Your Lordship. From 2002, one from 2006, one from 2007, and I'll give you detail later on. Just give a broad
Okay.
summary. Then I'll go to detail. Yes, they have been working as contingent worker continuously till today, Your Lordship. Then there's an ONGC Standing Order 1962, Your Lordship, which has been enacted by virtue of Industrial Employment or Standing Order 1946, Your Lordship. By virtue of the Standing Order, that becomes a statute, Your Lordship. We are claiming we have worked more than 180 days and 240 days in a year, so we are entitled for regularization service, Your Lordship. That's the crux of the whole matter, Your Lordship.
You raised the dispute.
No, I have not. I have came by it, Your Lordship. Why I have not? Here, what has happened regarding the employment of these people? There are several disputes which happened from the industrial tribunal to the apex court. There, they have their same plea have been raised that these are casual contract labor and this thing, and the project is temporary, seasonal nature, and work is not perennial nature, and all those things. Your Lordship, this ONGC project has been going on for the past more than 60 years, and so Supreme Court has it's a permanent project and it's a perennial character that has been. So what has happened, Your Lordship, right from because litigation right from 1992 or 99 onwards, there's an industrial award by the that time the industrial tribunal was there. They have given an award saying that all this contract, they engage contractor. This is all SAM thing, and this contractor, they are direct employees of ONGC. They are directly regularized. Against that, they came to the High Court. High Court, Larded Single Judge has dismissed the writ petition. Against that, they filed a writ appeal, which was allowed. And they, because writ appeal was that there are 2 mistakes in the writ appeal. One, writ appeal went that Steel Authority judgment was not considered by tribunal and the High Court. At that point of time, Steel Authority judgment came in 2001, and the award was passed in 2002. There's no question of Steel Authority. In fact, the Learned Single Judge has dealt with this thing, and the Steel Authority was considered and said Steel Authority doesn't apply to this. Because Steel Authority is only appropriate government definition was there. Thereafter, the Supreme Court has they set aside the division bench judgment, and since they raised certain disputes, some legal issues which they said writ appeal is not there. So it was sent back to this honorable court, and the division bench has again dismissed the writ appeal. Against that, they went to Supreme Court. That was all dismissed. So that another dispute was referred to Kachar, Your Lordship. Same thing happened. They raised the dispute of that casual contractor and all those things. There also the standing order. They have relied on the standing order and regularized that time. That matter where with the High Court and the apex court of that judgment is reported, Your Lordship. So that Supreme Court has affirmed that they are regular. They have to regularize that. Since they didn't do that, there's a criminal case filed in Sipsagari under section 26 and 32 of Industrial Dispute Act, and cognizance taken. Against that, ONGC came in, officer ONGC came in quashing before this honorable. It was rejected by this honorable court. They went to the apex court. It was dismissed, Your Lordship. So that's the position, Your Lordship, the whole thing. Now, Your Lordship, what has happened? The whole government, because two things are very important. There is a clear-cut finding that this beetle contractor, they just fought to deprive them the regular salary. That has helped the series of judgment. So there, Your Lordship, the apex court, this thing, they said, project is permanent, you cannot have anything. Then, Your Lordship, for engaging contract labor also, there are certain procedures. They don't have a license. Contractor doesn't have a license. Here, what they do, Your Lordship, the contractors are appointed for 3 years, and these people are country. What happened? ONGC say you take back this stuff. So that is not a purpose of contract labor. And
What about the case by where Mr. Dasgupta had appeared?
Yes, my lord. The laws
I
are
think
directly
it is
pointed out
directly
that.
connected,
Correct.
where the union had raised the issue,
Yes.
and it was
And
award-
here was MOS signed between the
right
parties.
in Gujarat.
Right.
Yes.
And this is the same case here also.
Your Lordship, here.
If there is a settlement
Yes.
under 18, it's
Yes,
binding.
that's our case.
No, Your Lordship, the settlement is over. The settlement is 2017.
That is
Settlement is-
continuing, my lord.
No, Your Lordship,
On that basis, we are paying.
Your lordship, the settlement is there. I have put place in record, your lordship.
No, Mr. Chaudhary, what we vaguely remember, we
Yes, your lordship.
Correct, my lord.
had,
That
dealt with
order
a
is,
matter where Mr. Dasgupta had appeared,
Yes, your lordship.
not Dasgupta.
yes,
No,
yes.
no, sorry, not Dasgupta.
Dasgupta sir and the opposite Mr. Sahibullah and Assistant Marshal Ma'am, that order is there. This is the order.
Yes, I think yes, Dasgupta had appeared. And there in that case, since ONG is the All India corporation,
When this is
And,
contractual labor union, my lord.
and we had passed a detailed judgment.
Correct, my
We,
lord. Yes, this
we
is
took
our,
into consideration section 18
And-
the implication of a settlement under
Right.
18. How it will be binding.
and they have
And
not challenged that.
Your lordship, we are not a member of the union. We are
No, no, no.
individual.
They have filed the affidavit. In the affidavit in opposition, we made a categorical statement along in the document that they have agreed to, the petitioners have agreed to the settlement, saying that we will not claim anything more. And this affidavit filed by them is before your lordship.
Yes, yes.
And therefore, since they are being paid on the basis of settlement and
Your
all the benefits have been given. So my lord,
Your lordship-
this is a case covered under section
Your
18,
lordship,
para 14, my lord.
I think there were two matters, Mr. Das.
Yes, two matters. Two matters, both are disposed of together, my lord.
your lordship.
Para 14, my lord. Section 18.
Chaudhary, are you aware of judgment?
I
No,
give
I'm
you-
not aware, I'm not aware of the judgment. Let it come day after tomorrow, your lordship.
Yes, because if it is the same issue,
Your lordship, here another issue which has not been dealt, how the contract, because they cannot engage contract labor under the act also, your lordship.
No.
Because for contract labor, there are certain procedures which have not been followed. Here, what they are doing, contractors are changing every 3 years. That is not a purpose of contract. And you cannot
a
deprive them.
similar plea was taken there also,
Yes, yes.
that contractors keep on changing, but our services are perennial in nature.
Yes, your lordship.
And therefore, there was a settlement by which some arrangements were made.
Benefits have been given.
Your lordship, the question is if your lordship see the settlement is still 31/3/2017. Beyond that, it's not continuing, your lordship. Settlement, if your lordship, their own document, their affidavit is saying that.
And on the basis they are continuing,
No,
and we are paying on the basis
no,
of.
you're right.
settlement.
We'll do one thing. Since
Mile.
we had applied our mind and remember,
Mile.
luckily this was the court. So let Mr. Chaudhary. go
Yes,
through.
it's sure.
Can I get a copy of the?
You can have this.
I'll.
You can have this court copy.
Okay.
Not an issue. We can have it after. Are you
Yes,
are you
yes.
around? After?
Definitely.
Hard to repeat Chaudhary.
Moreover, my lord, one judgment 2023 that earlier occasion, my lord has recorded that judgment, my lord, 2022 one SCC 463, my lord, their Kiluskar case, para 13.
Yes.
My lord, whether the condition of service, who has engaged, whether the contractor, same camouflage, and who pays them, who are under their control.
No,
So
no,
all
it's
this
okay,
has to
but,
be
let's
placed
have-
before the
let's-
labor
But
court.
this judge is Supreme Court.
Let Mr. Chaudhary have a chance to.
Yes,
He
sure.
may try to distinguish.
Yes,
the
there are the Supreme Court judgments are there which say it is
Yes.
camouflage. This matter, they are camouflage.
Court can.
Supreme Court affirmed it.
Or repeat Chaudhary, Senate counsel for the petition. Also heard to TK Das, Senate counsel, pending consequences.
Man.
It appears that the issue involved may be connected with an earlier case WP 04520, which was disposed of by this court
8/6/2020.
judgment and order dated 8/2020. Court that a copy of the court's judgment be furnished to each other by Sri Das so that then the matter be listed for hearing on the
Day after tomorrow.
Obligation.
May I please?
Yes, Mr. Rafiq, what is this?
My lord, the petitioner was the constable of Assam Police, my lord,
Constable.
constable, was dismissed from service, my lord.
Yes, this other side.
On 27 February 2020, Millard, he was dismissed from service and the petitioner. Oh.
We thought the other matter would continue for some time,
Lordship.
but there was an abrupt end.
It will continue, I think.
Continue. So we have
There are certain issues which are not being dealt with.
so we've shifted over to your case. Are you ready with the matter?
Yes, Lordship. We also have the records
This
also.
penalty matter will take.
Yes, Millard. On 27 February, Millard, he was dismissed from service and the
No,
petitioner.
no, what did you do?
I was a constable.
306. Petitioner constable where?
Head constable.
Head constable.
Yes.
Where?
I was working at Dispur police station,
Under the Assam police.
Assam police, UB.
Okay. Anambra.
Yes.
And?
Now, Millard, the petitioner has challenged this impugn order on two grounds, Millard. First,
No, no, first tell us what has happened.
Millard,
Why do you go to impugn order? What happened? When?
an affair was lost, Millard.
When?
4/2/2019, Millard.
4,
2/2019.
19. FIR law.
Affair was lost. The allegation was that
Let us see the FIR.
yes, Millard.
Let us see.
15A, Annexure 1.
Page 8,
15.
15.
Yes.
Yes, please.
A.
Yes.
Thereafter, Millard, the petitioner was suspended from service, Millard. and it
Where you named?
Millard?
Where you named it? Here?
No, Millard.
Some gold biscuits were taken away.
Yes, Millard.
They were possessing with authority.
Yes, Millard.
This person,
This person, Millard?
the informant had the authority to carry gold.
No, Millard.
Then?
This is their allegation. They might have got it.
No, 60 numbers of gold
It's
biscuits.
not possible normally. Illegally, they might have brought.
Illegally, then why will they lodge the FIR? If somebody is doing something
Wrong.
illegal,
Yes, Millard.
will he expose himself?
Yes, Millard. We have already filed a quashing petition also in this regard.
What is your name?
My name is Faizur Islam.
You are not,
Rahman.
the informant is somebody else.
Yes, Millard.
Okay, FIR.
All three persons were from Manipur.
It's good. Please. These poor peers.
Yes, sir.
Then what happened?
Thereafter, Millard, you will kindly say annexed to it's a suspension order, Millard.
You were suspended.
Yes. Annexed to page 18,
1-8.
1/8. Two persons were suspended. Number one is Nipu Kolita, he was SI, and me.
Yes, then
Thereafter, my lord, Tokos notice was issued, first Tokos notice on 6th of April 2019, Annexure 3.
page 19,
Page 19, Annexure 3,
6th April. 6th April.
6th April.
So forth.
Shokra.
Yes. How many allegations?
Page 21, my lord, statement of allegation.
Two allegation. Okay, then
Thereafter, my lord, DP was initiated, my lord. Inquiry officer was appointed. And your lordship will find annexure 5, my lord, the finding.
page
Page 25, relevant question, my lord.
except 5, page
Five.
25.
Page 25.
Findings of what? Inquiry officer.
Yes, my lord.
Where are the first part?
First part, my lord, only this much was furnished to me, my lord. I have also, in my reply, my lord, I have raised this issue also. Entire inquiry report was not furnished to me.
Entire inquiry was not given.
Not given. Annexure 6, page 26, my lord. I have written.
Where is your
Reply.
where have you said that only that page was given?
Annexure 6, page 26, madam.
Yes.
The first paragraph. With due respect and humble submission, I beg to state that I have been furnished only with a copy of findings, but the entire inquiry report has not been furnished to me.
In the repetition, where have you stated?
I have not stated my report.
Why? This is a very important point.
Yes.
You have not stated in your repetition. It's very strange. Okay, then.
Thereafter, my lord, annexure 7, the dismissal order.
Annexure 7.
Annexure 7.
Where is the reply? Reply is at page.
Reply is at page 26, annexure 6.
Where is the second so-called notice?
Second,
24.
yes, my lord.
8 November. What is this date of your thing?
Date of my
Of your reply?
date of reply.
25.
Yes.
Reply. Then what happened?
Then, my lord, the impugn order, my lord, annexure 7, page 29.
Page 29.
29.
'27 2000. Dismissal. Okay. Yes.
Now, my lord, the petitioner has challenged this impugn order on 2 grounds. Number 1, my lord, the complainant, on the basis of whose complaint, my lord, the DP was initiated, was not examined, my lord. And whether the complainant was correct or not, and to establish that, my lord, he was the right person to speak with veracity. My lord. And secondly, my lord, there was a selective punishment here. DP was initiated against two persons, one SI and one Faizur Rahman, the petitioner. And lesser punishment was given to SI. Only one increment was stopped, my lord.
Who's the SI name?
Nipu Palita.
Need to,
Nipu Palita.
sorry, it was SI. It was the imposed punishment of what?
In my
Imposed what punishment?
only
increment.
one increment was stopped, my lord. In my additional affidavit, my
Doesn't
lord,
matter, imposed, suppose the one punishment, one increment.
one increment.
Okay.
Penalty of stoppages of one increment with cumulative effect. Your lordship will find it in my additional affidavit, my lord.
Yes, doesn't matter. Yes.
Okay. So only, so my lord, I would like to refer some judgment of the High Court and the Supreme Court, my lord, in this regard, that selective punishment is not permissible.
No, first you address on the first ground, the complainant not examined.
Yes, my lord. He was not examined, my lord. None of them were examined. Your lordship, kindly say, only the 164 statement was considered.
First, let us understand the allegations against. Let us read the so-called first so-called at page 19. The first allegation.
Yes.
Please read
Yes, my lord.
that on page 19. Annex
Page
3.
96 of April,
Yes.
first show cause notice.
Yes,
Yes,
that
my lord.
on second paragraph.
Second paragraph.
That on
Date on 4/2/2019.
Hmm.
The complainant Wajuddin Shah, son of so-and-so, lodged an affair at Dispur PS stating that on 15/1/2019, the complainant along with two of his companions, namely Wahidur and Azmir, were traveling from Jurabat to Shillong in a taxi with 60 pieces of gold biscuit. But they were detained by a group of people comprising of police from Dispur at about 9:45 p.m. and the 60 gold biscuits were seized from the complainant and his companions. The complainant and his companions were then dropped at different locations under Dispur PS and no report of the seizure was made at Dispur PS. Hence, the case was registered by Dispur PS case number so-and-so under section 392 IPC and investigated into. During the cross-examination, the complainant and his companion, Wahidur Rahman, were examined and their statements were recorded under section 161 CRPC. The statement of the complainant and the witness corroborated with the FIR, and they also stated to have identified two of the accused police personnel as SI Nipu Kolita and Head Constable Faizur Rahman, the petitioner of Dispur PS. During investigation, it is found that on the date of occurrence, that is 15/1/2019, SC Faizur Rahman along with AG Abdal Ali was the driver of the Papa 6 vehicle. AG Kupshal Ali was examined and his statement recorded under section 161 CRPC. As stated by him, SC Faizur Rahman and AG Abdal Ali on 15/1/2019 departed to some place with the SI Nipu Kolita of Dispur PS in the Papa 7 vehicle at about 8 a.m. and returned at about 11 a.m. The driver of Papa 7 vehicle, Havildar Bolin Pukon, was examined and his statement recorded under section 161 CRPC. As stated by him, SI Nipu Kolita, SC Faizur Rahman and AG Abdal Ali boarded the Papa 7 vehicle on the DO at about 8:30 a.m. and all three of them were dropped at a Shillong highway after Jorabat as per orders of SI Nipu Kolita, who was in civil dress, and all three of them then went away towards Shillong in a Swift Desert vehicle. Later at about 2 p.m., SC
yes, we have read. We have read. List of documents. List of witnesses. Bahaduddin was the complainant, right?
Yes, my lord.
In the second page, page 20, list of witness,
Yes, my lord.
complainant,
Complainant Wajuddin, Azmir and Wahidur. Three complainants.
Azmir and Wahidur.
Wahidur. Wahaduddin Shah, Azmir Hussain and Wahidur Rahman were the complainants. They were not examined.
Okay. And how was this proof against you?
So nothing has been found against us.
No, in the
No,
inquiry
no
report,
recovery, nothing. My lord.
no, what is, how is the allegations proved against in the inquiry? In the affidavit which the respondents have filed, have they annexed the inquiry report?
No, my lord.
Madam,
Lordship.
even without going to any other aspect, you have not given him a fair chance to show cause against the inquiry report.
Lordship, that I have seen, Lordship.
He is, we tried to extract from him whether he has stated this in the in the writ petition. There is no such statement, but
Lord,
he is correct in pointing out there is a big drawback. He should have pleaded. But in the reply, he said that I have only given the
Lord.
fine.
Lordship.
Have you denied it?
Second, Lordship. This has not been denied, Lordship.
And if we may not go to the aspect of pushing out the aspect of discrimination,
Lord,
penalty of SI and him different. But the aspect of the complainant not being examined,
complainant also examined, Lordship,
Mm,
but
mm.
do you have a copy of
Lordship, if your Lordship may kindly peruse our affidavit para 9, Lordship,
your affidavit?
probably running page 53.
Page
53, running page 53, Lordship.
here,
There are none.
Para 9, Lordship.
not this is some other. By affidavit by whom?
Affidavit by the Deputy Commissioner, Police, Lordship.
Subhasis Barua,
Yes, Lordship. Subhasis Barua.
para 9.
Para 9, Lordship.
It is at page 63.
Oh, 63.
No, it was initially 50. There was some
Okay, mistake.
alteration. Yes.
Okay, Lord. In that para, Lordship, we have stated, the answer and deponent states that opportunity was given to the petitioner to defend himself by cross-examining the witness Habildar Bulin Fukan, but
Where have you stated?
paragraph 9, Lordship.
Okay, okay, right.
But the petitioner stated that he was nothing to say. This is their Lordship.
But you have not given him the inquiry. Only to find
He was not the complainant, Milan. Havildar Bolin Pukan. I was waiting for the
Did you
complainant.
examine the complainant? Do you have a copy of the inquiry report?
Lordship, we have the. We have. Wait. Lordship, we have Lord.
Let us see. You have the proceedings also. Inquiry proceedings.
Yes, Lordship, proceedings is there. Lordship,
Early conducted.
Lordship,
See there, you have named a number of witnesses
Lordship,
in a DP. Even if the complainant is absent, in an exceptional case, we would have gone ahead with taking into account the nature of the charges.
Lord,
Only one witness had deposed. He did not say anything about the gold biscuits. He said, I drove them.
only he dropped.
Then they went to Maruti,
Yes,
Shillong
Lordship.
by Maruti Drift. Next day, he handed over 20,000.
Yes, Lordship.
And what is important is that your inquiry officer, in spite of the fact that the other witnesses were not there, relied upon their 164 statement, which they had
Lordship.
given in the criminal case.
Yes,
There is
Lordship.
no bar.
Lordship.
But the requirement of law is that once you rely upon the statement,
Yes,
that witness has to present himself for cross-examination by the judge.
yes, Lordship.
He may not come with a fresh
Yes,
statement.
Lord.
He may just come, I have already given the state 164, you can cross-examine. But without giving him the opportunity, the inquiry,
Lordship, Lordship. We admit,
the
Lordship.
charges are so serious. Why do you give to matters
Lordship.
in such perfunctory manner? Should have training of the officers. These are not new laws. These are laws settled decades back.
Yes, Lordship.
How do you initiate a DP? What are to be taken into consideration? What is a reasonable safeguard?
Lordship. I think probably presently this has been taken up, Lordship. by the government lordship sensitization program and all this.
If the matters do not come up for examination,
Yes,
scrutiny,
lordship.
before a court matter ends there, but once it comes up for judicial scrutiny, then we have to ensure that the law is followed,
Lord.
because there may be abuse, misuse.
Yesterday, while I was going through the entire record lordship, I also find this loophole.
And
Lordship.
that part, you have not said anything. Of course, you may say that in the repetition there is no pleading, so there was no occasion for us to
Lordship.
reply. That fact that only the findings were given. But in his reply, there is a statement
Yes, reply.
that only the findings copy have been given.
Lordship, then the allegations remains lordship. So lordship may provide us the opportunity, lordship.
See,
With
if
a
you,
liberty,
if
lordship.
you go for a defective inquiry,
Lordship.
not furnishing inquiry, what is the technical ground?
Lord.
Now here the ground is a substantial ground. We have to interfere with it. Had it been a
Lord.
case that yes, inquiry done, copy not given, gone ahead.
Is
We were,
one
normally
thing.
we say that no,
Yes,
from that
Lord.
stage, give a copy and initiate. Now,
Denial of
the
opportunities.
inquiry itself is vitiated. And the allegations is of which year?
2019 lordship.
And my lord, another person,
It's
my lord,
not
the
that-
SI, on the same set of allegation was also there against him. He was given only lesser punishment, my lord. That is also not permissible.
There are difference of opinion where one, it all depends on facts and circumstances. One may be given less punishment, one may be given more punishment. But only because one is given less, you want a lesser punishment, that is not.
The thing was that, my lord, in his case, my lord, in his case, my lord, in Nipu Kalita's case, my lord, they could have not examined the complainant on that ground, my lord.
Even here you have not examined. And we
Here
are,
also. So why there are two types of punishment?
where is the case brought? Regarding examination of witnesses
Yes.
in a DP.
One is 2002 GLT, my lord.
Supreme Court.
Supreme Court, my lord. Supreme. Yeah. And that.
Citation.
Okay.
The second case, my lord.
Yes, what happened in Hardwari Lal? What happened in the first case, Hardwari Lal?
Consider করেছিল না? জানা নেই না? May I read the relevant part of the
Yes.
Hardwari-Lal?
Yes.
The fact of the case in Hardwari-Lal versus the state of UP and others is that the appellant constable in the police department was subjected to the departmental inquiry on a charge that on the night between 16/17/1999, being under the influence of liquor, heard abuse in a police station at Constable Prakash Chandra Pandey. The complainant Sri Virender Singh for the said alleged occurrence and the witnesses who had been accompanied to the appellant to the hospital are the material witness for the said occurrence, but they were not examined in the disciplinary inquiry against the appellant. The Apex Court held that non-examination of the said two material witnesses shall not only cause non-observation of principle of natural justice, but also cause prejudice to the appellant in defending his case, and accordingly, there was no proper inquiry held by the authority.
Yes, next.
In the para 3,
Rajendra Yadav.
Para 3, before us, the sole ground urged is as to the non-observance of principle of natural justice in not examining the complainant, Sri Virender Singh, and witness Jagdish Ram. The tribunal as well as the High Court have brushed aside the grievance made by the appellant that the non-examination of those two persons has prejudiced his case. Examination of these two witnesses would have revealed as to whether the complainant made by the Virender Singh was correct or not, and to establish that he was the best person to speak to his veracity. So also Jagadish Ram, who had accompanied the appellant to the hospital for material examination, would have been an important witness to prove the state or the condition of the appellant. We do not think the tribunal and the High Court were justified in thinking that non-examination of those two persons could not be material. In these circumstances, we are of the view that the High Court and the tribunal are in not attaching importance to this contention of the appellant.
Yes, next.
Then, my lord, in paragraph 4, however, Sri Goyal, the learned additional advocate general state of Uttar Pradesh, has submitted that there was other material which was sufficient to come to the conclusion one way or the other, and he has taken us through the same. But while appreciating the evidence on record, the impact of testimony of the complainant cannot be visualized. Similarly, the evidence of Jagdish Ram would also bear upon the state inebriation. If any, the appellant. Now, my lord, the para 5. In the circumstances, we are satisfied that there was no proper inquiry held by the authority, and on this short ground, we quash the order of dismissal passed against the appellant by setting aside the order made by the High Court, confirming the order of the tribunal.
Okay.
May I read the last 3-4 lines.
Yeah, we have read. Next is Rajendra Yadav, where are you citing? Discriminatory punishment.
Yes, this one. Yes, Rajendra. Yes, Rajendra.
Now you have given a case. Right.
Paragraph 13. May I read?
Para
13.
on 3.
Oh, 12 and 13 is important.
Yes.
Merit. The doctrine of equality applies to all who are equally placed, even among persons who are found guilty. The person who have been found guilty can also claim equality of treatment if they can establish discrimination while imposing punishment and when all of them are involved in the same incident. Parity among co-delinquents has also to be maintained when punishment is being imposed. Punishment should not be disproportionate while comparing the involvement of co-delinquents who are parties to the same transaction or incident. The disciplinary authority cannot impose punishment which is disproportionate. That is, lesser punishment for serious offense and stringent punishment for lesser offense. Para 13. The principle stated above is then applied in few judgment of this court. The earliest one is Director General of Police and others versus D. Dashan 1998 to SSC 407, wherein one Dashan, a police constable, along with two other constables and one head constable were charged for the same act of misconduct. The disciplinary authority exonerated two other constables, but imposed the punishment of dismissal from service on Dashan and that of compulsory retirement on head constable. This court, in order to meet the ends of justice, substituted the order of compulsory retirement in place of the order of dismissal from service on Dashan, applying the principle of parity in punishment among co-delinquents. This court held it may otherwise violate Article 14 of the Constitution of India. In Shailesh Kumar Harshad Harshadai Shah case, the workman was dismissed from service for proved misconduct. However, few other workmen against whom there were identical allegations were allowed to avail of the benefit of voluntary retirement scheme. In such circumstances, this court directed that the workmen also be treated on the same footing and be given the benefit of voluntary retirement from service from the month on which the others were given the benefit. In this way, it was interfered.
Anything else?
No, this is judgment, I think.
There are judgments to show that 164 statement, if you rely, you have to have the witnesses in front of you.
Yes.
They have relied upon 164 of the other witnesses.
And Miller, in the list of documents, Miller. Miller, they have considered 164 statement, but in the it is absent in the list of documents.
But it's not, see, this particular witness was a named witness, these two witnesses, namely Wahiduddin and Wahidur.
Wahiduddin, Azmir, and
Wahidur. So there, instead of them coming to the inquiry, their statements have been used. Now there are case laws that if you use the statement, there is no bar in using the statement made under 164. But you have to be given an opportunity of cross-examination.
Yes.
Have you got those case laws?
That fair case laws I have not got.
Anything, madam?
Lordship, as Lordship has already pointed out, and I'm also admitting that the proceedings has not been conducted in a way that could have
Could
been
have been.
Lordship.
You're correct.
So Lordship, that Lordship may kindly direct the disciplinary authority to
Let
Lordship
us see what we
to
can do.
inquire into the matter, Lordship, from the where it has been vitiated or the right of the petitioner has been infringed, Lordship. And I can refer to judgment, Lordship, but right now I don't have this,
Which one?
Lordship.
Judgment?
Lordship, one is Chairman LIC of India and other versus A. Masila Money. This is reported in 2013, 6 SCC 530,
What
Lordship.
has been said?
Lordship, the contents, Lordship, regarding the Lordship, the inquiry, where it is vitiated, Lordship. In that case, Lordship may
No, yeah,
power to direct.
this is not a question of where an inquiry is vitiated on technical ground.
Lordship.
Here, there is a substantial error in the inquiry. Just as we have pointed out, suppose you did not hand over a copy of the report.
Lordship.
From that stage, we can say that hand over. Now the inquiry itself is vitiated. We can still, but taking into account the
The
seriousness of
charges are seriousness of the charges,
we may
Lordship,
give
and they
you-
have not imputed the charges, Lordship.
we may-
It remains, Lordship. This is
we may give you some report.
One more judgment I would like
And
to
that will be
relate.
of a discipline
2010
force,
5
Lordship.
GLP. Division bench judgment, Miller, of our High Court.
Hmm.
2010 5 GLP.
What has been said?
Miller,
What has been said?
here, Miller, regarding the punishment, Miller, two types of punishment. And
Parity.
and
We'll
also
not,
the
we'll not go into parity. Don't worry.
Yes.
Hard. Turn it off. submitted. The issue which has been raised in this writ petition is with regard to a penalty of dismissal of service pursuant to a disciplinary proceeding. Full stop. The challenge is based both on the aspects of, both on the grounds of procedural, grounds of illegality, both from a procedural and substantive, and parity in imposition of penalty. Please have your seat. Have your seat. The petitioner was working as a police constable, UB, and was serving as the head constable at the Dispur PS in the year 2019. Full stop. What happened to the appeal?
Miller,
What happened to your departmental appeal?
departmental appeal, it was rejected, Miller. NHK Miller. Case 39. Annexed K. Anything.
2019. At the at the relevant time. Full stop. An FIR was lodged in the state police station on 4/2/2019 by 3 informants with regard to illegal seizure of certain gold biscuits allegedly by officers of the Dispur PS. Full stop. The FIR, however, does not contain name of any accused person. Full stop. Be that as it may, comma, the petitioner was arrested in connection with the state FIR, which was registered as Dispur PS case number 363 of 2019 under section 390 of the IP. Full stop. Owing to such arrest, comma, the petitioner was placed under suspension on 9/2/2019 and which was followed by initiation of a disciplinary proceeding by issuance of a so-called notice dated 6/4/2009. Full stop. The petitioner had replied to the so-called and not being satisfied, comma, an inquiry was initiated by appointment of an inquiry officer. Full stop. Though the inquiry was held, though the inquiry was held, comma, none of the relevant witnesses were produced, and only one number of witnesses was produced whose version as projected by the petition is also not or does not also implicate the petitioner in any with any offense. Full stop. The enquiry report, uh, the petitioner was served with a second show cause notice with only the findings of the enquiry report without furnishing the entire report. Full stop. Para. On 25/11/2019, the petitioner had submitted his reply, and on 27/2/2020, the petitioner was dismissed from service. Full stop. The departmental appeal preferred by the petition has also been rejected, and accordingly, the writ petition has been filed. Full stop. I have heard Rafiq, learned counsel for the petition. Full stop. I have also heard M. Bhattacharya, learned additional senior counsel from Assam, representing all the respondents. The United States Council has also produced the original record of the departmental procedure. There are three Rafiq, the Learned Counsel for the petitioner, has structured the present challenge on two broad grounds. Firstly, it is contended that the entire proceeding is vitiated as the petitioner, as the procedure established in law was not followed at all, and the petitioner was not given an effective opportunity to safeguard himself. Full stop. He further submits that apart from the procedural irregularities, materials have been relied upon which could not have been done, which are not permissible, and materials have been relied upon in a manner which is not permissible under the law. Full stop. The Learned Counsel for the petitioner has also taken the plea of discrimination in imposition of the penalty by citing the example of another co-delinquent, namely Sri Nipu Kolita, who was the SI against whom the penalty imposed was only stoppage
Of one increment.
of one increment with cumulative effect.
Yes.
Full stop. The Learned Counsel highlights that the reason for the lesser penalty is non-examination of the relevant witnesses, which and the same reason was also available so far as the petitioner is concerned. It is submitted that in the show cause notice submitted that the FIR was the genesis of the department proceeding, in which there were three number of informants, and all the stage informants were made witness as their name and their names were given in the list of witnesses accompanying the show cause notice dated 6/4/2009. However, none of the aforesaid, not even a single, none of the aforesaid complainants had appeared in the inquiry report, in the inquiry, and therefore the entire allegation against the petitioner should not prove. Full stop. The Rafiq, the learned counsel, further submit that in the second show cause notice dated 8/11/2019, only the page, only the last page of the inquiry report containing the findings have been forwarded, and to substantiate have been forwarded on a specific query regarding pleadings in this regard, though the learned counsel has admitted that there is no pleading in the writ petition, he has referred to his reply dated 25/11/2019 to the second show cause notice, in which it has been categorically stated that only the findings have been furnished to him and the entire inquiry report has not been furnished. Full stop. It is submitted that by such procedure adopted, the petitioner was deprived of making an effective reply to the second show cause notice, by which he could have convinced the disciplinary authority to take the authority not to accept the findings of the inquiry and accordingly exonerate the petition. Full stop. He submits that such denial amounts to violation of his fundamental rights, and therefore the present is a fit case for interference. Full stop. Sarah? Coming on to the second ground of challenge, it is submitted that the penalty imposed is discriminatory vis-a-vis a co-delinquent, namely Sri Nipu Kolita SI, who was also an accused in the criminal case, as well as a criminal case against whom a similar DP was initiated. Based on the same set of witnesses and an allegation, the state officer was imposed the penalty of stoppage of one instrument only with cumulative effect. Sarah, in support of his submission, the traffic, the learned counsel for the petition has relied upon the following case laws. Number one, Hardwari Lal. Number two, Rajendra Yadav. Sarah, in the case of Hardwari Lal comma, the Honorable Supreme Court has held that non-examination of material witness in a departmental proceeding would be fatal and would be a ground for interference. That in the case of Rajendra Yadav, comma, the Honorable Supreme Court has dealt with the aspect of discriminatory punishment for ready reference on paragraph 12 and 13 of the judgment is expected herein below. Par contra, comma, MS Bhattacharya, the Learned State Council, has submitted that the allegations are very serious in nature and those are to be examined vis-a-vis the position of the petitioner, who was a protector of law, as he was posted as the head constable. Full stop. They submit that the allegation constitutes and involves section 392. Is it 392 of the IPC, which is a very serious offense? He further submits that taking into account the seriousness of the offense involved, comma, the punishment imposed may not be held to be disproportionate and according no interference to be made. Full stop. The Learned State Council has, however, placed on record the original file of the disciplinary proceeding of Tara. The tribal submission made by the Learned Council for the parties have been duly considered and the material placed for this court have been carefully examined. The grounds taken in the writ petition and urged by the Learned Council for the petition was on the basis of the material which were made known to the petition. However, a perusal of the file of the disciplinary proceeding make certain alarming disclosure. Sarah. The so-called notice dated 6/4/2019 had contained a list of witnesses of 11 numbers and a list of documents also of 11 numbers. The said list of witnesses also had the names of the 3 complainants based on whose information, comma, the police case was registered and is basis of the present. However, from the report of the inquiry officer, it appears that none of the complainants had appeared before the inquiry officer. In fact, out of the 10 numbers of cited witness, only one witness had appeared, being Havildar Bolin Fukan, who was the driver of the vehicle. The statement of the MS Bhattacharya had also submitted that there is a finding that the petitioner had declined to make cross-examination of the witness. On a perusal of the statement made by the sole witness, Havildar Bolin, though it appears that the same statement is correct, as no cross-examination was made, in the chief examination, there was no allegations at all having any element of offense or misconduct, and therefore, simply by the fact that the witness was not cross-examined cannot be a ground to draw any adverse inference against the petitioner. The inquiry report also suggests that certain documentary evidence were taken into consideration, which include the 164 statement, includes the statement made by witnesses Wahaduddin Shah and Muhammad Wahidul Rahman, made under section 164 of this year. It may be mentioned that the aforesaid two witnesses were also the complainants in the criminal case. However, what intrigues this court, However, what intrigues this court is that why the statement of those witnesses made under section 164 of the CRT was taken into consideration, the said witnesses were not produced in the DP, so as to give the petitioner an opportunity to cross-examine them based on the statement, on the pre-recorded statement. Though it may be permissible to produce a pre-recorded statement which may be in the nature of a statement made under section 164 of the CRPC in a disciplinary proceeding, the requirement of law would be to afford the delinquent an opportunity to cross-examine the state witnesses by securing their presence in the DP, which in the instant case was not, and therefore the pre-recorded statement could not have been used in any manner against the delinquent. This court, with regard to the second show cause notice, the entire objective of such second show cause of such notice is to give the delinquent an opportunity to persuade the disciplinary authority to not to take, not to accept the views of the inquiry officer which are against the delinquent. Full stop. The requirement of such notice is one of the essential safeguards which a delinquent is entitled to. Full stop. However, in this case, it appears that the same requirement of law was made was made into a mere formality by forwarding only the last page of the inquiry containing the findings. Full stop. That not correct. Though there is no specific pleading to that effect in the writ petition, this court has noticed that in the reply of the petitioner dated 25/11/2019 to the second so-called notice, the state point was specifically taken, and in the impugned order of penalty dated 27/2/2020, there is no such denial. Those Rafiq, the learned counsel for the petitioner, has also highlighted on the aspect of merit in imposition of penalty, since this court has come to a conclusion of there being serious error, both procedural and substantive, in the inquiry, this court may not be required to go to that aspect of the matter. In view of the aforesaid facts, circumstances, this court is of the unhesitant opinion that the impugned disciplinary proceeding from the stage of holding of the inquiry till which had culminated in the order of dismissal dated 27/2/2020 is unsustainable in law and accordingly satisfied. So, consequent, the petitioner is directly reinstated in service. At this stage, the government advocate has submitted that liberty may be granted to hold the inquiry afresh by taking into consideration the seriousness of the charges and also the connection with the criminal case involving section 39 of the Act. Having considered the aforesaid sufficient, while the impugned order of penalty of dismissal dated 27/2/2020 satisfied, the authority would be at liberty to hold a fresh inquiry on the allegations which were leveled by Choco's notice 6/4/2009 to facilitate holding of such inquiry, the authorities would also be at liberty to post the petitioner in any non-sensitive. The record, the original record of it is handed over back. Not today, we'd have it.
Lordship,
লিবার্টি দিলে
রিইনষ্টেট দিয়ে দিলে দেখুন
এটা দিলে
আৰু কি লাগে ফোন লৈ হেৰি কৰিছে
হ্যাঁ।
আৰু কি লাগে
হয়
পুলিচ কেইটা এনেকাই
হ্যাঁ
What is the